And welcome back to the Michael Cohen Show on our continued journey to 500,000 subscribers. We're getting there. I think we're 13,000 now. Yesterday was a fabulous day thanks to you. So hit subscribe, watch, comment, and share. Share this with family and friends because this lunacy, this stupidity, it must stop and stop today. So grand jury transcripts are rarely released. And the fact that they are central to James Comey's case is unprecedented. But everything right now is unprecedented in this administration. Ty Cobb, former Trump White House attorney, he said that Lindsey Halligan should actually be disbarred. Play the clip.
This is an indictment, though, that doesn't really have to be dismissed. It doesn't really exist. It was never properly returned. So I think what we heard today, shocking, never occurred before in American jurisprudence. I think will be dispositive. But on the other hand, there's so many dispositive issues here, including her illegal appointment.
Well, I do want to ask you about that. You've said that you think both Halligan and Attorney General Bondi could be disbarred over this case against Comey. And that was before we learned what happened today in court. It also raises questions for me that if you're going to use Lindsey Halligan in this manner, the fact that she has no experience, is anyone overseeing that work to make sure that problems don't arise? But what do you think now?
Well, I do think that both Halligan and Bondi should be disbarred. Bondi has twice submitted affirmations to this court about the propriety of Lindsey Halligan's grand jury presentation. She knew this. There's no way she could not have known this, and that's just means that she lied. Or that she's equally incompetent, but more likely that she lied.
Yeah, let me tell you, that's pretty scathing, especially coming from Ty Cobb. Now, in another very rare moment, Lindsey Halligan, she released a statement criticizing, of all people, the judge. Let me show you what it said. In it, she writes, personal attacks like Judge Nachmanoff referring to me as a puppet don't change the facts of the law, she said, meaning Lindsey Halligan. The judicial canons require judges to be patient, dignified, respectful, and courteous to litigants, jurors, witnesses, lawyers, and others with whom the judge deals in an official capacity, and to act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. My focus remains on the record and the law, and I will continue to fulfill my responsibilities with professionalism. Well, a lot could be said about professionalism. Now, on Political Beatdown, my co-host Ben Meiselas and I, we actually broke down the craziness of this situation. Play the clip.
Let's talk, though, about the update on Donald Trump's favorite prosecutor, Lindsey Halligan, the beauty pageant contestant turned insurance lawyer with no federal prosecutorial experience at all, who Donald Trump handpicked to lead the Eastern District of Virginia prosecution against James Comey after the career prosecutors, including the Republican interim United States attorney, was basically fired by Donald Trump and pushed out. And that former Republican United States interim attorney wrote a memo to file saying that there's no evidence to go after Comey, no evidence to go after New York Attorney General Letitia James. So I just want you to think about this from the perspective of a criminal case, where the standard is reasonable doubt. When you get that document in discovery and one of your exhibits to the jury is, we got a memo. Who's it from? The prosecutor's office. Which one? Them, from their office. And what do they say? That there's no evidence to go after my client? Really? So not only did they say there's no reasonable doubt, they said there's no evidence at all. So the first part of this hearing with Halligan that took place earlier, which was Comey's request for dismissal, one of the things that I thought was the bombshell, right, was that the prosecutors did not turn over that memo. Like, we know that there's a memo that says, don't prosecute Comey by a Republican interim United States attorney who then got fired. There's no evidence. So they didn't turn that over. Why? The DOJ and the deputy AG's office says, don't turn it over. So to me, that was the first moment. But then, Cohen, they go to, did the grand jury ever receive the actual two-count indictment that became the indictment that they purportedly voted on in order to indict Comey and find probable cause. And during the hearing, Lindsey Halligan and the prosecutors both said, we never showed the actual indictment to the grand jury. We just showed it to the foreperson and one other grand juror. And so people may be saying, the hell? How does that happen? It never happens, ever. Never has happened.
Let's just say that's a pretty significant procedural.
Never has happened before. So there's no like, well, when this happened, no, it never happens. Why? Because you have competent people who do this. So what appears to have happened is that Lindsey Halligan first presented a 3-count indictment to the grand jury. And according to Halligan and the DOJ, the grand jury rejected the first count, but accepted the final 2 counts. However, that's not what the document says. The document says that they rejected all 3 counts. According to the Halligan story, because they approved 2 counts, she had to print out another copy to get them to sign off on that. That copy was never presented to the grand jury, but Lindsey Halligan had the foreperson and somebody else and another grand juror who was there sign off as though it was presented to the full grand jury and they hadn't seen it. So I'm going to try to read this, but my eyes, Cohen, are not the greatest right now. This says, after the November 19, 2025 hearing on the defendant's vindictive prosecution memorandum, the Eastern District of Virginia grand jury coordinated, informed, okay, after they put that, it was so small for me. Coordinator informed the undersigned that the grand jury foreperson informed her that they had returned a true bill as to counts 2 and 3 and not as to count 1. The coordinator was informed by the deputy criminal chief to amend the indictment by removing the text of the former count 1 and moving the remaining counts 2 and 3 to reflect as counts 1 and 2. And that it was the coordinator and the foreperson who were the people who were in the room, but not the full grand jury. Well, today, now Halligan's team filed a notice of correction.
Right.
And their notice of correction goes and says, well, the foreperson stated in the transcript that the grand jury approved this. And so what they're trying to do, now the foreperson is just like a regular citizen who got a jury notice, right? So the foreperson doesn't know the procedure, right? That the indictment needed to be showed to the entire, to the entire grand jury. Yeah. So now they're trying to blame the foreperson,
right?
As though the foreperson, look, the foreperson said it, but yesterday,
is the foreperson supposed to know how the process works, or are they just there on behalf of the grand jurors, the grand jurists? So let me be crystal clear about something, all right? And I've watched now a multitude of former federal prosecutors turn around and say, yeah, I didn't even know that there was a notice of correction that you can file, simply because in the 38 years that I've been practicing law, I've actually never had or never heard of anybody filing such a thing. I don't even know if what they're saying about this notice of correction is even something that exists. I mean, literally, I couldn't find it. I looked for it. I suspect maybe that there is something.
No, I practiced in federal. There's something called a notice of errata, right?
Yes.
And I filed notice of erratas before, and maybe you do a notice of errata where your case citation is like 33 cal.app.333-5, but it's 333-4, right? Errata. judge, and this is what would cause you panic as a lawyer sometimes, because when you were going through your table of contents, I remember how diligent I would be as a litigator to make sure every point was whatever. And if I made a mistake, I'd like, oh my God, we need a notice of errata. I told the judge that the case starts on page 334-5 and it was 334-6. The idea of a notice of correction, which after you do your hearing, you go and say, oopsies, everything we told you at that hearing on the substantive issue in the hearing as officers of the court, where we said that only the foreperson and one other grand juror saw it. Actually, we've now uncovered something that we had in our possession, weeks ago, because it's the grand jury testimony. And actually, we're going to just say the foreperson mentioned that this was approved by the grand jury. So we're going to just put it on the foreperson, and the foreperson didn't know. The foreperson was given something to sign by this interim fake United States attorney and Lindsey Halligan. And so the foreperson is not the legal authority. The legal authority is you idiots. It's the lawyers who are there. And if you wanted to make this argument, when you make them in court. You know what this would be like? And I'm sorry to all of our Toronto fans with the Blue Jays losing the World Series to my LA Dodgers. This is what it would be like after the game is over. Notice of redo, and people like, the game's over.
I want to take that pitch back. All right.
I'd like to take the pitch back. Notice of repitch. And
Ben, what this really reminds me of? Seriously, what this really reminds me of, and I know you're going to finally agree with me on this one. This is like the movie My Cousin Vinny. And I really want to be Fred Gwynn, the judge in this, and go, pretending that Lindsey Halligan is Vinny Gambini, right? Because this is the kind of procedural stupidity that Mr. Gambini, it's like, did you just say ute, right? What is a ute? I mean, that's what we're talking about here. This is, okay, I'm with you on that. People make citation errors. Maybe you hit, instead of 333, you did 3333, just simply because it happens. So you do the notice of the correction, the errata. I get it. But those aren't significant errors that is the predicate for the entire motion. Yes, what you're doing is you're doing a correction so that the record reflects it correctly, that if there's an appeal or something, that they go to page 333, not 3333, which doesn't exist. I get that. This is the entire procedure that they are now turning around and saying. I mean, this is like, we kind of like did the whole thing wrong. So but I will tell you that what it does do is it gives them the ability, if granted, to avoid the statute of limitations violation that would exist if they brought the case now.
How so?
Because the motion that they're bringing brings it back to the date of the filing as a correction and not as a new issue.
I'm not sure I agree with that. You're saying
it does.
Which thing, though, you're talking about? Like Pam Bondi has tried to retroactively. They couldn't go back to the grand jury now.
No, what she's saying is that they don't have to, that they're just correcting the record onto it, even though the record is completely screwed up because procedurally it was done wrong. But what they're saying is if we brought back the grand jury and we showed them the documents and so on, and that they agreed to the indictment, well, then lo and behold, it's correcting the record, not
I don't think you can. I don't think you can bring back.
I'm not saying that I agree with it. I'm saying that this is the argument.
They could argue that they'll build a time capsule and go back and maybe tell Lindsey Halligan that she should. I mean, there's so many things that they could do, but like, you can't bring this. You can't re-impanel this same grand jury tomorrow. It's done. They're done. They've been released of their obligation. The proceeding is over.
Hey, everyone. First of all, thanks for watching. I mean, we're going to be posting daily episodes with reactions and talking about politics. We'll be talking about everything, in fact. So please like and subscribe. Join us on this journey.